Hello, everybody, and thank you for being here. Welcome to this masterclass by Consuelo Constituten at the Austral University School of Law here in Buenos Aires, Argentina. It's a pleasure for me as the head of the Law and Language Department to be hosting this talk today on a very special topic, which is the structure of a contract in English, which is key to our plan of training lawyers in legal English. So I would like to tell you that today's masterclass will be by Consuelo Constituten, and she will, when she finishes, we will take questions. So if you have any questions during her talk, do not hesitate to write them in the chat, and I will read them to her when we finish. I would like to tell you some things about Consuelo. Maria Consuelo Constituten has a Bachelor of Laws from the University of Buenos Aires School of Law, an LLM from King's College London, and a postgraduate degree in Regulation of Financial Markets from the London School of Economics. Consuelo is an Argentine lawyer specializing in international commercial law with more than 25 years of experience in the United States, Brazil, the United Kingdom, and Venezuela. She's also a university professor with more than 20 years of teaching experience, both at the undergraduate and postgraduate levels. She's currently the director of the postgraduate practical and intensive course in legal English and the contract drafting workshop at Austral University. She's the academic coordinator and a professor of the postgraduate diploma in hydrocarbons law organized between Austral University and the University of Salamanca, Spain. At the undergraduate level, she teaches common law institutions at Austral and other classes in institutions such as the University of Buenos Aires at the Law School and at the School of Economic Sciences, Torcuato Di Tella University, and other institutions. She's also a linguistic consultant with the largest law firm in Argentina, Marvalo, Farrell and Mayral, and she's proficient in several languages, namely English, French, Spanish, Italian, Portuguese, and Turkish. So without further ado, Consuelo, the floor is yours. Thank you very much for being here with us today, and you can share screen whenever you want.
Thank you, Mariano. I don't want to leave out a very important thing that is on October the 5th, we are starting a new course, which is a workshop on contract drafting. And after this short masterclass, you can contact Karina Molina or anyone at admissions to know a little bit more about the workshop that will start in October. Okay, thank you very much, Mariano, for that lovely presentation. I'm going to share screen and we are going to start with our presentation today. So the idea and what it's important to bear in mind when we are either drafting or reviewing a contract that is construed and governed by any law of the common law, mainly US law or UK law, but any law of the common law, we have to remember that in common law jurisdictions, we don't have a civil code to resort to. So mainly what we write in the contract will be the sole ruling for that, the sole and the only, actually, the whole rules that will govern that negotiation. Therefore, it is important that we bear in mind not only all aspects. For example, if we think of force majeure, we have to understand that in English law, force majeure is a creature of contract, and we won't have a civil code with a definition of force majeure. So we have to define it in the contract. Likewise, when we are drafting a contract in English that will be interpreted, and I will talk about that later on, under the doctrine of the four corners of the contract rule, the courts in common law jurisdictions tend to be very strict when they interpret contracts. So it is not often, and it is not common to resort to other material or other sources to interpret a contract. All the sources of interpretation of a contract should come from the same contract. So you have to be wise when drafting. And the last thing that I want to mention is that a contract that's construed and governed by common law has a different structure than the other contracts that we are used to see in our civil Roman-based jurisdictions, legal jurisdictions. And what happens is that many times we see that Anglo-American companies and foreign companies in general, sometimes companies that are not based in common law jurisdictions, but they prefer, however, to have the structure. Maybe the governing law is the law of the country of execution, which is, by the way, quite advisable. But they want to keep this structure that I'm going to explain today. So this structure that I will explain and these tips that I'm going to give you will be not only useful for those contracts that are governed by any law under common law, but also that are construed under the structure of contract construed and governed under common law. So first things first, you have to understand that this structure and some of the clauses will be different from those clauses that maybe you're used to in your countries and your mother tongue. So being that said, let's first talk about some tips for drafting a contract and some things that we have to bear in mind before getting into the structure of the contract that would be the drafting. First and foremost, we have to understand, and this as a linguist and also as a frequent drafter, we have to have in mind that we use several languages when we draft legal documents. When I draft a memo, I use objective language as opposed to a brief or a motion that will use persuasive language because I'm trying to persuade that judge or that jury to actually rule in my favor. Now, when I draft a contract, I use more than 10 different languages. And these are the language of agreement, language of performance, because I have to explain the performance of the obligations, the language of obligation, and I will get into this a little bit more in depth later on, as the language of obligation involves modal verbs. It's not the same thing to say you can, then you shall, then you must, then you will. So we will talk about language of obligation later on. Language of discretion, the language of prohibition, and beware with double negatives there. Language of policy, language of declaration, language of belief, language of intention, and language of recommendation. There are many tips and tricks in how to use these languages. Unfortunately, we will not be able to cover all of them today. We will talk about language of obligation, which is most important today. But yes, this is part of my my different courses, we see not only in the program of Practical Legal English, but also in the program that starts in October, which is the writing workshop for contracts. Okay, so my tips on drafting contracts. Try to use your own words. You know that there is a movement that has been going on for the last 40 years at least, of plain language, of using actually plain common words to draft legal documents. And this is because we are, I think, tired of seeing disputes, and I will refer to contracts. Of course, plain language is needed in regulation, in judicial resolutions as well. But in contracts, we have seen a lot of disputes arising out of badly drafted agreements, and agreements that are difficult to interpret because they are written in a way that sometimes not even the drafter knows what they wrote. So try to avoid legalese as much as you can. I understand that, and when I started practicing law, legalese looks good and looks good on the sheet of paper, and the herein, hereof, herein above, herein below, here around the corner looks nice, but it is big, and we are trying to bring clarity, bring precision. A contract should be precise. So if you are not precise, actually, if the obligations are not determined clearly, then dispute arises, which is what we are trying to avoid. Okay, so let's take a look at these examples. Seller has not entered into any contract or agreement, and contract and agreement are synonyms, to sell or encumber the property or any part thereof. Don't you think that this sentence can be written a little bit more clear? Let's take a look at this other wording. Seller has not entered into any other contract or agreement to sell or encumber the property or any of its parts. Actually, I can say only agreement or contract. Yes, the sale and the encumbrance, they are different things, so I have to keep those. Let's take a look at another example. Borrower acknowledges that lender is about to fund the loan on the date contemplated hereby. Again, the hereby, hereof, therein, thereof. See how I can get rid of the hereby. Borrower acknowledges that lender is about to fund the loan on the date contemplated by this agreement. What am I doing here? Providing clarity. Or on September the 15th, 2022. Be clear, be precise. Instead of saying herein above, say in section 3.5. Instead of saying thereof, in the amendment or in the side letter number 2 dated June the 22nd, 2020, for example. Okay, remember that when we talk here, herein is in this document, in this act, in this contract. When I am talking therein, it's in another document, in another transaction, okay? And now we get into the language of obligation. If you look up the word shall in the Black's Law Dictionary written by Brian Garner, you will find that shall has 5 entries. This means that shall is a word that in legal English has 5 different meanings. What happens? It is unclear. Sometimes we don't know whether shall is acting as may or as will or as must, because actually it can go either way. And I have to take into account context, drafting, and the general obligation described. Now, if I change the shall and I replace it by will or by must, depending on the sentence, then I will find that I reach more precision. I get more precision in the definition of the obligation. Let's take a look. Seller shall reimburse buyer for all delivery fees. How can we change this? We can say seller will reimburse buyer as we're talking in the future. Or in this case, particularly in this case, we could use must as well. In the case that is very common, this agreement shall be governed when we establish a duty to perform. Then I prefer to use will. The agreement will be governed. And in the first example, both can work, but I would prefer to use must. So whenever you find a shall, think, can I replace it with must? Is it an outright obligation? If it's an outright obligation, then must is your better option. If it's an obligation in the future, then use will. Try to replace the shall as much as you can, and you will achieve actually a definition that's more precise, an obligation that's better defined, and a contract that, all in all, is better written. Use short sentences. Short sentences are key to plain legal English. Why? Because actually, we are tired of reading. And in a way, you know that reading a book, it's like watching a film. And that shouldn't be an exception with legal documents. You can build an atmosphere, you can build in you can create suspense. You can, if I say the police barged in the house of the accused, the way I write, the structure I use, if I separate my ideas into sentences, one idea per sentence, I will achieve better clarity, and I can also work with the sentence in structure to give emphasis to my writing. And this is particularly useful when I'm writing motions, briefs, or pleadings. Remember, pleadings are the complaint, answer to the complaint, the counterclaim, and the answer to the counterclaim. Well, going back to the drafting of contracts and the use of plain English within the contract drafting, it is important to bear in mind that sometimes we have to describe a certain obligation, for example, the deliveries, the inspections, And sometimes we find that we end up writing very long sentences. Now, my take on that is, and this is a personal tip, if a sentence is longer than 3 lines, cut it short. Try to divide it, to choose the 2 main ideas and divide the sentence and link that sentence with a connector. We have connectors of likeness, likewise, or connectors of, for example, of addition, like moreover, furthermore. We have connectors of contrast, like however, nevertheless. Use connectors. Try to use short sentences, 1 idea per sentence, and connect those sentences. And also paragraph. Paragraphs are key to structuring a contract that's readable and understandable. And if you use vertical formatting and numbering and bullet points, we will find that it is better to, and it is easier to find things in a contract. In my professional experience, I've worked with very long contracts. I've worked a lot with construction contracts, with contracts that are really, really long and have a lot of exhibits and ancillary documents. So it is important to have a correct numbering and then maybe an index, so we can resort easily to find what we need. Always using the active voice. In a contract, there is no use of in using the passive voice, and this is something that's pretty incredible, hard to believe, but lawyers tend to use a lot passive voice in contracts. Actually, passive voice is used by journalists in their newspaper articles, and there is no need to use passive voice in a contract. Why? Passive voice, it's, you know, that in any language, and English is no exception, we have a structure to our sentences. The structure in English and in Spanish is the same: subject, verb, object. What happens in passive voice is that the object is flipped-flopped, turned with the subject. So instead of saying, my uncle read the document, I say, the document was read by my uncle. But there is one more possibility, which is to omit the subject altogether and to say the document was read. And I don't know who is actually the performer of that action. And that's a problem in contracts, particularly in contracts, because I need to identify who's the actor, who's the obliged party to that specific obligation. So try to keep the core of the sentence, this subject, verb, object. Okay, so when you're reading a sentence in a contract, try to think, where's the subject, where's the verb, where's the object, and rearrange them in that order. Okay? Take a look at this example. Shareholder A may not, without the prior consent of shareholder B, transfer the Class A shares to any person, and see how we can rephrase it. Shareholder A may not transfer the Class A shares to any person without the prior consent of shareholders B. Don't you think it's clearer that way? It is more straightforward. It is understandable in the first reading. And that's one of the key objectives when you write. Whenever you're drafting, think that that thing you write, that piece you're writing, should be understood by your reader the first time he or she reads it. Now, beware of modifiers. What's a modifier? A modifier is a word, can be an adjective, an adverb, that modifies another word. Many times, what happens is that that modifier is misplaced. So I don't really know what word, what concept is that modifier really modifying. And what's the solution? To place that modifier as close as possible in the sentence to the word that it modifies. Now, if I say no litigation against the seller is pending or to the knowledge of the seller threatened, I really don't get much the clear idea. I have to change the placement of those modifiers in order to have a clear sentence. Now, if I say, for example, the secretary found the if I say the memo of the lawyer, the secretary found the lost memo, the lawyer's lost memo. Now, I have to get the word lost as close as I can to memo, because sometimes I can draft that sentence in a way that I don't know who the secretary found, whether the lawyer was lost or the memo was lost. Okay, so the idea with modifiers is that we place them as close as possible to the word that we are modifying, and take into account that many types of words can act as modifiers. Avoid nominalizations. What are nominalizations? Nominalizations are verbs that act as a noun. And as lawyers, we tend a lot to use these words that end in shon and sion. They're all nominalizations. Actually, the information was given to the party. The party was informed. Okay, see how it's clear? It is clearer to say the party was informed, that the information was given to the party. And see how in the information was given to the party, I'm using the passive voice. And by actually eliminating the nominalization, I'm also getting rid of the passive voice. Okay. Typical nominalization, the issuance, immediately following issuance of the stock, immediately after the corporation issues the stock. Try to rescue that verb from the nominalization. Then, main tip for drafting contracts: define, define, define. Define your terms. Why? Because those terms will have the meaning that you give them for that contract. And that's the great difference with the contracts in civil Roman-based jurisdictions, where I have a civil code that will tell me what's the definition of force majeure. However, in my contract under English law, for example, force majeure will mean what actually my definition of force majeure in the contract says. Okay, so define the terms, and which terms should be defined, of course, would depend on a case-by-case basis, but those that always bring and are complicated because they bring out disputes, and they end up in disputes because of their lack of clarity and because they may have different meanings in different legislations, maybe in the same country, state, local, federal law. Some examples: affiliate, subsidiary, controlled company, company grouped, controlling stake, change of control. Then when we are talking maybe of loan agreement or financial contracts, MAC, material adverse change, or material adverse effect. Whenever I have an M&A, the purchase of stock purchase, there I need hidden liabilities, bad debt, undisclosed liabilities, unregistered liabilities for the determination of the price. So think which are those concepts that may lead to a discussion and ultimately a dispute, because they are unclear, because maybe I have different interpretations. Maybe I have a company's law that says that the controlling stake should be over 33%, and then I have the banking entities law saying it is more than 20, and then I have another regulation that it says it's over 10. So for my contract, controlled entity will be X. So those are terms that I suggest you define. There are many more that you will, of course, consider depending on the particular contract. But one thing that is important, and is as equal as important as defining your concepts, is to use them consistently. If I am defining the sold goods as the goods, then goods, and I can choose whatever conspicuous language I wish, whether all caps, whether the first capital letter, which is generally the convention, or bold, or underline. Generally, I prefer not to use underline, as it can be confused with links and it's slowly being left out of use. But show it in a way that the reader knows that that's a defined term. Now, once you have placed your definition, you have defined the term, and that term is used as a definition in conspicuous language, then don't make the mistake of using that same word not as a definition with the conspicuous language, or the other way around, using that word as a definition without the conspicuous language. For example, in the case of goods, Don't say goods again. Try to say items or widgets, okay? Try to use another word so that the reader knows that's not the definition. Consistency is key when drafting a contract. Again, vertical formatting, sections and subsections, numbering. Why? Because we don't read. We don't. We scan. And this is actually clinically proven that we scan documents. We go from left to right, from upwards downwards. 1, 2, 3, 4, 5. We scan. So whenever we see a bunch, a clog of things in a very, very, very long format that has actually no spacing, no white parts, it's all little letters, then you don't want to read. So try to use a font, and personally, I prefer sans serif fonts. The serif, it's the little termination. For example, Times New Roman is a serif font. I prefer to use Arial because I think that Arial is a font that actually it's easy to read, and I try to use font 11 upwards, okay? Try to use 11 upwards so it's easy to read. Also, if you structure your contract by separating your ideas and sentences, separating paragraphs, numbering those paragraphs, you will find that instead of a big block of text, you will have a text that is more easy on the eye, and therefore it is more easy to read and to understand. Okay? So far, so good? Let's get into the contract and let's analyze the structure of a contract in English. As most international jurisdictions, a legally binding contract requires an offer and acceptance. And the offer and the acceptance, I'm sorry that here the key is a little bit low. The offer and the acceptance is the agreement. Then we have the consideration. The consideration is the exchange of mutual obligations. And again, different meanings for the same word. I can say in plain English the consideration of facts. I'm considering, I'm weighting my options. Now, consideration in a contract is the exchange of mutual obligations. It's what we call in Spanish contraprestación. Contraprestación se dice consideration in English. Description of the mutual obligations, capacity, competence, governance, and dispute resolution. Those are the basics. But let's take and see the structure of the contract. First and foremost, I will talk a little bit more about how contracts are interpreted, and I have already mentioned this. The four corners of the contract rule, and this comes from the four corners of the sheet of paper where the contract is drafted. And this parole evidence rule or rule of the four corners that is widely used in common law, both UK and US case law have accepted the doctrine of the four corners of the contract. Understands that we cannot resort, except some specific cases, to outside sources to interpret the contract. So my contract should be fully sufficient. What means fully sufficient? That I have to give my interpreter, my reader, my recipient, all the necessary tools to understand the functioning of that contract and of that particular operation that is described in the contract. The evidence that is allowed, because this doctrine has changed over time and has loosened up a little bit, is to correct a mistake, to clear up ambiguous language, to assist the judge, to clarify a transcription, to prove that the original contract is invalid, to prove that consideration was never offered, to show that a party committed fraud, or there was a tort, or there was an unconscionable behavior, the doctrine of unconscionability, to make changes to the original contract, to name parties involved in cases of changing names. But actually, these exceptions are allowed by the court once the dispute has risen and once I am in court. So why don't we save us all that trouble and define, write clear, have a good structure, and try to build a sufficient, self-sufficient contract. Okay, let's get into the structure then. A general structure of a contract that's construed and governed under any law of the common law will have first a preamble, which will be the title and the description of the parties, and then the recitals, which will probably begin with the word whereas. That is purely legalese. It is being left out, but the preamble and the recitals are not enforceable. So beware of not including representations and warranties or covenants in the recitals. And if you need to include a representation and warranty in a recital, then repeat it in the reps and warranties. I'm going to go over that in a minute. But the preamble will have the description of the parties, and I will have, if I have more than one party, more than one company or person, whether natural or fictitious, in one same party. Let's say I have two sellers, I have three buyers. I will say as a party of the first part, and then as a party of the second part. Now, again, purely legalese and something that is being left out gradually. I explain it because you'll probably see it. But Brian Garner, for example, is adamant in taking that party of the first part and party of the second part out of the contracts. They are candidates for the job, but you'll probably see them. Okay, so preamble and recitals non-enforceable. Then we go to the definitions. The definitions can be introduced all through the contract, but sometimes in contracts that are long and complicated, and it is good practice to have the first article of definitions. Sometimes you have definitions in an annex or exhibit. I strongly recommend you put them in the principal contract as the first article of section. Then we go to the conditions precedent. I will explain later on that conditions precedent are those events that need to happen either for the contract to be in existence, to come into existence, to start into force and start working, or to trigger some obligations under the contract. Okay. Then representations and warranties, and we will see that in English law we have a differentiation to reps and warranties, as a misrep may bring the contract null and void, whereas the warranties and those representations that are not key to the contract, that is to say that the counterparty has not relied upon those representations to enter into the contract, then they can be actually cured and they lead to a breach, as opposed to the key representations that, yes, lead to a misrep, and therefore the contract may be reputed null and void. Then we go to the action sections. The action sections are the consideration and the covenants. What are the covenants? The covenants are the determination, are the limitations to those considerations. And actually, those covenants can also be restricted by provisos. Caveats, carve-outs, and baskets are provisos. Provisos can be provisos of thresholds or provisos of obtaining authorizations. If it's of obtaining authorizations, I will talk about red tape baskets. Remember, when we are talking about red tape, we're talking about obtaining a governmental approval, okay? Then we come to the remedies. What happens if one obligation or several obligations are breached? Remember that we always call for breach. You call a breach of contract. That's the verb we use, to call a breach. Now, we have in our civil Roman-based jurisdiction this conception, this idea, because we have that solution right made for us, ready in our civil code, that whenever we have a breach of performance, I must request specific performance before asking for compensation. In those contracts that are governed by common law, it's exactly the opposite. Actually, to ask for specific performance, I must go to the courts. In the case of breach of performance, I have access to a compensation, which we called liquidated damages. And what are liquidated damages? It's an amount of money that the parties beforehand think that it is reasonable to cover the direct damages. Doesn't cover indirect damages, doesn't cover consequential damages, never, ever, doesn't cover punitive damages, because the intention is to actually replace the damage, not to punish. And that is why they're called liquidated damages, and generally how we draft that clause is saying that that compensation is given as liquidated damages, not as a penalty. Then the term and termination, whether it's renewed, and there we have the evergreen clauses, and sometimes I may have some obligations that may survive the contract, such as confidential obligations, for example, and then we get to the boilerplate. The boilerplate are all those general provisions that also called endgame, because they are at the end, that are fundamental and that really are key to the contract, but they are the similar to most any contract. What happens is that the boilerplate may be the same in a construction contract and in a sale and purchase contract. And sometimes we are so tired of discussing the action sections that when we get into the boilerplate, we say, oh, well, this is all the same. Never do that. Governing law, force majeure, severability, assignment, key clauses are within the boilerplate. And then the annexes and exhibits. And if your boilerplate is correctly drafted, you will have a clause that says entire agreement, that says that all ancillary documents and annexes and exhibits form part of the same document and all form one contract. Let's take a look at these parts one by one. So preamble states the title, let's say sales agreement, the place and date of execution, and then at the end we will talk about why it is not necessary to repeat the date and the place of execution at the end, and that legalese made up phrase in witness whereof the parties here execute. Remember, in English, to execute is to sign. You execute a contract. You celebrate a party. Okay? Let's celebrate. Come on. Not a contract. You never celebrate a contract. You execute a contract. You negotiate a contract, but you never celebrate a contract. The parties enter into a contract. Okay? Now, place and date of execution in the preamble at the very top. No need to the in witness whereof, and no need to repeat that information again. Why? Because maybe you make a mistake, because maybe you are drafting and redrafting, and the first draft said September the 14th, and then you end up executing on September the 15th, and you change it in the preamble, and you forgot to change it in witness whereof at the end, and now we don't have a clear date and we have confusion. So try not to repeat the information. Okay, again, by and between if I have two parties, by and among if I have more than two parties, or if one party is formed by more than one person. In that case, we use party of the first part, party of the second part. This is a little bit in disuse now, okay? In between the preamble and the recitals, we use linking words that are called witness, witness, or witness that. And generally, we are trying to get rid of those as well. Recitals. What are the recitals? What we call considerandos. They provide the background of the contract. Remember that recitals are not enforceable. They, yes, provide a history. They might provide the and give a lead as whether for example, the services provider is an experienced company. But if you are willing to make that experience binding, a binding obligation, then repeat that in the reps and warranties. Let's go to the definitions. The definitions are key, and as I said before, try to be consistent. Conditions precedent, as I said before, are those events, those facts that must happen to actually get the contract running, to make the contract effective, and that would amount to condición suspensiva in our Argentine law, or in most of our civil Roman-based jurisdiction, or trigger certain obligations, condición de cumplimiento. So conditions precedent are condiciones suspensivas and condiciones de cumplimiento. Never una condición resolutoria. Condición resolutoria is condition subsequent in legal English. Reps and warranties. The difference between a rep and a warranty, and I've already mentioned this, is the remedy available. You will find that in the US, reps and warranties are treated as synonym. Note in the UK. In the UK, reps actually lead. The breach of a rep may lead to a misrep and may lead to the contract being null and void, whereas the breach of a warranty then can be cured. Now, in the US, what we have is the main representations and those that are not key to the contract. Those main representations, also called principal representations, that are the representations that actually have been taken into account by the counterparty to enter into the contract, are the ones that, if unvalid, will lead to the nullity or the contract being considered void. And actually, it is good practice to include that in the wording, okay? The typical wording for introducing a rep on warranty is the seller represents and warrants that. You'll probably have seen that, haven't you? Okay, consideration to be valid should be legally sufficient and bargained for. And what's a covenant? A covenant is a limitation to that obligation. You can have several obligations in a contract, and all the determination, all the limitations to those obligations, those contractual conditions are called covenants, okay? We have many types of covenants, and the covenants will depend on the area of the law. And actually, it is important that those covenants are written correctly so that the obligation is correctly defined. So I have an obligation and I have a limitation to that obligation. And then I can have an exception to that limitation. My covenants can be of two types: affirmative, things that I'm allowed to do, or negative, things that I'm restricted to do. For example, in a loan agreement, the obligation of the borrower is to repay the loan. Now, that obligation may have covenants. Affirmative covenants will be to maintain a ratio debt to equity, or to maintain financial statements, or to be in good standing, or not to close branches or lines of business. But for example, negative, not to close branches or lines of business, not to sell assets, not to pledge or encumber. But I can have a limitation to those covenants. If I say that the, for example, borrower must not sell assets, and I can say, except for those assets that have reached their end of life value. Okay, that would be a outright exception. Now, I can have a carve out. A carve out is when I take out, I carve wood, I take out different and specific aspects. So I can say that a borrower may not, must not sell, is actually forbidden to sell its assets except for this and that other asset, and I identify the asset. Or I may have a basket. I may say borrower is not allowed, must not sell its assets, with the exception of those sales under $5,000. That's a basket, an amount of money, okay? Here you have a proviso. I introduce a proviso with the words except for, however provided, however that. Remedies, I already talked about specific performance and its difference with our civil law jurisdictions. And in our civil law, we find it unnecessary to include remedies. Take into account then in those contracts governed by common law, I must include a remedy, okay? As specific performance can only be requested before court. So the entitlement to damages must be included in a specific clause called liquidated damages, not as a penalty. Term, as I already said, provides the term of the contract, and we have contracts that can be renewed automatically. If I say this agreement must become effective on the date first above written, which is wording that I don't recommend, I prefer will come effective on September 15th, 2022, and will remain in effect for 1 year instead of for the period of 1 year, and renewed automatically unless one party receives a 60 days non-renewal notice, a non-renewal notice with 60 days prior in advance. So, or a 60 days prior notice to not renew. These are called rolling contracts, okay? That's a rolling clause when it's automatically renewed unless a notice of non-renewal, a non-renewal notice is sent. Okay, termination with cause or without cause. We don't say rescisión, resolución. Rescisión would be termination with cause, and resolución would be termination without cause. Okay, let's get into the boilerplate before finishing. Governing law. The parties may choose the law of each of the parties or the place of execution or a third law. I am adamant about two things. One, that the governing law should be at least the law of the domicile of one of the parties, or preferably the law of the place of execution of the main obligations, taking into account that if public policy is involved, such as employment contracts, governing law will be the law of the place of execution of the services. Now, if I choose a third law, take into account, please, that law has to be taken into consideration for dispute resolution and also for the structuring of the contract. Sometimes I want to actually exclude a regulation, such as for example, convention, United Nations Convention of International Sale of Goods, which is many times excluded by sellers mostly. Then a dispute resolution, whether judiciary courts or arbitration. And here you have examples. My take and my advice to you is, if you're going for institutional arbitration, go with the model clause of that institution. The assignment, what's the assignment? Cesión, okay? Cesión is assignment. Cedente is the assignor, and the assignee is el cesionario. We don't talk about cedents, only in insurance, okay? So maybe I have a provision that allows assignment for subsidiaries and affiliates, or maybe it's a prohibition. Now, it is important to deal with assignment. And it is important to define subsidiaries and affiliates, okay? Severability, what is severability? Severability establishes that in case that one clause is reputed null and void, then the whole contract stands, and it's only that clause that it's void. An entire agreement, as I said before, is that the whole lot of documents actually form one agreement. It's the documents, ancillary documents such as side letters or MOUs or exhibits and annexes, okay? That is the entire agreement. Waiver. Waiver, it's an important clause, and there are a lot of important provisions within the endgame provisions, because actually you can have particular waivers or general waivers. The particular waivers are called affirmative waivers, but generally what we say in a waiver provision is that if any party takes any action or inaction, that does not imply the waiving of a right. For example, in a sale and purchase agreement, if, for example, the seller does not deliver on time, but actually the buyer knows because they've been in contact that there has been a delay, and this has been the bread and butter every day story within our pandemic days and the aftermath as well, then if the buyer does not call default right away because the buyer knows that the goods are going to arrive a couple days afterwards, that does not mean that the buyer is waiving its right to call default, because maybe if the goods don't appear after 2 weeks' time, it calls default. That is why it is important to include a waiver provision, okay? And there you have a wording. Survival, what I told you before, those provisions that and those obligations that survive the contract. Confidentiality, insurance, some disclaimers, limitations of liability. Generally, what we will see is that confidential information and confidentiality obligations will have a larger term of validity, or even maybe evergreen. Force majeure is a creature of contract in English law. So what have you have to take into account when drafting force majeure? Describe those events, okay? Generally, events that are act of God. But for example, with COVID, even if you had pandemic as an event, actually, which was the direct cause of the breach of obligation? Was the pandemic, or was actually where the regulations and limitations imposed by government as a result of the pandemic, okay? So be careful when you draft your force majeure. Describe those events, provide how, when, and to whom you have to give notification, the notice that a force majeure event has occurred, and then elaborate, establish a procedure, how to work when that happens, and whether allocation is allowed. Confidentiality, again, key to most agreements and very important when drafting to consider whether you are on the disclosing side or in the receiving side, or maybe is both, okay? Language, always, and this, I say this because I've suffered by experience. We were discussing a very complex document many years ago. Actually, it was the construction contract for a thermoelectric plant. And we were in Brazil, and we were discussing with many parties a covenant in the English version. And then we realized that the governing version was the Portuguese one. So we were wasting our time. So always amend the governing version. And my advice to you is actually translate at the end. Sometimes you have to work with the parallel drafting because you have to have the English version and the Portuguese version because your party does not know or is not comfortable with Portuguese. But try to keep a close eye on the versions being updated, okay, at all times. Always try to choose the language of the contract that's the same language that's used in the jurisdiction that belongs to not only the governing law, but also the dispute resolution option. Whether it's arbitration, the language of arbitration should be the language spoken at the place of arbitration, and the same thing with the judiciary courts. Notices, beware of including a specific provision that allows electronic notices, okay? And finally, we reached the end. And generally, we end the contracts with the notices and this in witness whereof. And I am against that phrase, as I already said, because it's legalese. Let's take a look at those legalese phrases, and they are more than 10, but these are my best picks that actually we can delete from our contract. So next time you draft your contracts, try to avoid this one. For the avoidance of doubt. If you have to say for the avoidance of doubt, actually just write it clearly, be precise, okay? Included but not limited to, or without limitation. Sometimes you need this because you're giving an explanation that has certain kind of possible scenarios or possible events, or I'm giving an enumeration. And I want to say that that is simple an enumeration and it's not taxative. But I can say not limited to. Try to make it shorter, okay? Or just using including and the list of events. That's okay too. This one is a treat. Without limiting the generality of the foregoing. It's when we give an example. If we give an example, we put E.G. comma. That means example. However, if I want to actually explain a little bit more, then I.E. comma. That is to say, y rest, okay? So get rid of without limiting the generality of the foregoing. A lot of words with no avail. Subject to the terms of this agreement. Maybe subject to, or except as provided, as the case may be. Arising out of or in connection with. We all love this one. This one we all love. From or related to. Try to go to the point, be clear. Maybe you get rid of 7 words with just replacing them for 1. except as otherwise agreed. Be specific, okay? Try to really engage your reader. And actually, if you want to say except as otherwise agreed, actually the parties can agree an amendment, but use other qualifiers or subordinators that are one word, such except, or limit your obligation. But these wordings are a little bit confusing, okay? And they also make the interpretation harder. Not to be unreasonably withheld. When is it reasonable and when is it unreasonable? Sometimes you get this when there are authorizations, when there are consents. And yes, sometimes we see this and sometimes we have to include it. But actually, I prefer to, instead of making emphasis in the reasonability, I make emphasis in the delay, for example, okay? So not unreasonably delayed or not delayed more than X days. If consent is not given within 15 working days, always working or calendar days, always be specific, then it will be understood that the consent is given, for example, or on the contrary, that it is denied. But create a little proceeding and solve the question, because then you're just creating future scenarios for dispute. Was it reasonable? Was it unreasonable? One party will say it's reasonable and the other party will say it's unreasonable, obviously. Shall be deemed. Wording that really goes nowhere, okay? That's a road to nowhere, okay? Generally, we say deem when it is considered to be fulfilled, a condition, or a regulate, an obligation that arises from a regulation. But actually, it is used so redundantly that in most cases we can delete it outright to the maximum extent permitted by law. That is understood. We understand that when we are drafting contracts under common law, where, for example, companies can perform all acts and they don't have this limited corporate purpose, all acts insofar they are legal with the limitation of it might be considered in very, very, very rare cases that we may have an act that's so different to the corporate purpose that may be null and void. But actually, in common law jurisdictions, the companies do not have a limited purpose, but actually the corporate purpose can be anything insofar it is legal. Then we try to avoid this wording. In witness whereof. This is a wording that this is a sentence that can be deleted altogether, and a result of modern plain English. Fortunately, you will be seeing that modern contracts don't have it anymore. Now, try, if you do have that phrase in witness whereof the parties here too have executed this agreement and duplicate as one for each party as of the date first above written. That's legalese at its top form. Then try to either put on the date first above written, and actually then there is no use, or include the date, okay? And take into account that that date is the same date that it is above, it is stated above. And you don't have the, actually it is a mistake that I've seen committed often, that you have one date in the beginning of the contract and one different date at the end, because they ended up executing on a different date. So my advice to you, delete the in witness whereof altogether. And we've reached the end of our presentation, and I will be taking your questions until the 6:30 or 6:30 the hour. And that is all for the class of today. I hope I have been clear, and any doubts or queries, please, you can just write them in the chat. Mariano,
Thank
do
you
we
very
have
much.
questions?
Thank you very much, Consuelo, for your presentation, which was very in-depth and thorough. And I think our audience now must be clapping on the other side. We can't see them, unfortunately, but I am. Thank you very much, Consuelo, for this very good presentation. I will read to you one question we have from Fernanda Norato. She wrote this at the beginning of the presentation. She said, what about deictics? And I think she's referring to, she answered, Fernanda said, this is in connection with hereby, here to, herein before, herein after. And I think you mentioned something about that. So I don't know if you
Yes,
want to
they
add
are.
anything.
Yes, I will add. Those are legalese words. We say legalese when they are technically legal. And mainly the here part means to this document, to this transaction. And the there part means another document. My recommendation is actually to be precise. It's instead of in connection thereof, in connection with that transaction, and you name the transaction in connection with the distribution agreement, let's say, or as provided in herein below, as provided in section 5.3 of this agreement. So there is no way of misinterpretation, because if I say as provided herein below, I really don't know which section you're referring to. But if I say as provided in 5.3, I go to 5.3. Okay, so the herein, hereof, herein above, herein below, it is very common. You will see it a lot, but try to think, do I really need it? Can I be more precise? Can my party benefit from that precision? And if the answer is yes, then replace it.
Very good. Thank you, Consuelo. We have here a comment by María del Carmen Urquiza, who says, muy buena y completa la presentación. Muchas gracias. Thank you very much, María. If any of you wants to ask a question in Spanish, you can write that in the chat and I will read that to Consuelo. Don't worry about that. And I have a question for you, Consuelo.
Yes.
The other day I heard that there is a term coined for those clauses that are translated from one language into the other. And the term was Frankenstein clauses. What do you think about them? For example, when we have a clause like a clause discussing consideration, it's translated into Spanish, and it makes sense if it refers to the common law, but then the contract is applied and enforced in Argentina, and it doesn't make any sense. What do you think about that? How do you deal with that as a lawyer?
Well, first and foremost, always remember to have a severability clause so that if we have any clause that actually can be challenged, then that does not affect the rest of the contract. But I think that the Frankenstein clauses end with a good drafting, with a good writing of the clauses in plain English, using all the different tools and tips and tricks that I gave you, short sentences, using connectors, using the right word, be precise, call a spade, okay? No need to go around the bush. And I believe that 30 years ago, when I started in 1992, it was well seen. It was like it actually it gave a lawyer status to actually manage that legalese, but not any longer. Now, a good draft is a draft that gets read, and a good contract is a contract that does not give way to dispute, okay? And you can make money by drafting more contracts, not by ending in lawsuits. So actually a good contract, it's a contract that's straightforward and clear. So always be clear, be precise, be on point.
Thank you very much, Consuelo. I think that is very wise advice. We have a question here from Belinda Alba. She says, good afternoon. Do the expressions without prejudice to the above provisions and notwithstanding the above provisions mean the same?
Yes, and actually there is a slight difference between those, but again, it is legally. I mentioned one that's pretty similar. Think if you really need it, and think whether you can draft it in a way that any Mary, Peter, and Joe can understand, okay?
Thank you very much, Consuelo. And we also have a comment here by Antonella saying very helpful indeed. Thank you, Antonella. So if we don't have any other questions, this is it. It's been 1 hour and a half of deep, in-depth knowledge on contract law. Thank you very much, Consuelo. Please remember that Consuelo will be teaching a contract drafting workshop at Austral starting in October through November. So if you're interested, please stay in touch, and please also stay in touch if you're interested in legal English in general, because at the Law and Language Department at Austral, we are offering other courses too, so you might be interested. Again, Consuelo, thank you very much. And
thank you, Mariano, for having me. Thank you all.
Thank you.
Bye-bye.
Bye-bye.